Where you live makes all the difference in getting your ERISA disability benefits. The First Circuit seldom strays from upholding disability insurance carriers' requirements that a policyholder produce objective medical evidence of a disability. Look, there's no uniform disability insurance policy in the United States, and every carrier will have multiple versions of a disability policy, even multiple versions that they'll sell to the same employer. Rarely do employers and their human resource departments understand what they are offering to their employees. That can come back to bite a disabled employee who has paid for their disability policy thinking that they were buying financial peace of mind if they became disabled. One of the worst policy terms you can find in a long-term disability policy is one that requires a disability policyholder to produce objective medical evidence of disability. Now, many policies will have a laundry list of conditions that are not considered to be objectively based, like fibromyalgia. Now, I get it. Fibromyalgia may not always have objective findings, but this laundry list can include post-operative back conditions characterized only by pain, or migraines. So let me give you an example of how this works. This is the case of Santana Diaz versus Metropolitan Life, and it's a First Circuit case, not a friendly place. MetLife had paid 2 years of benefits under the mental nervous limitation. Now, she had diabetes and had diabetic neuropathy in their hands and feet that caused tingling and numbness. The policy required objective medical evidence of clinical findings of nerve pathology to continue the payment of benefits beyond 2 years. Unfortunately, he didn't submit any evidence of objective medical findings or even an EMG or nerve conduction study test to document the diabetic radiculopathy. So MetLife denied his claim. The policy gave MetLife the discretion to interpret the term objective medical evidence and to determine if there was any such evidence in the claims file. The First Circuit has a history of upholding and deferring to disability insurance companies in determining if there's any objective medical evidence to support a claims denial. And that meant, unfortunately, for Mr. Santana Diaz, that the claim denial was upheld. The lessons to be learned here is first to understand the terms of your policy and what you have to prove. Is there an objective evidence clause in the policy? And if so, how is that term defined? Secondly, if you have one of those terms in your policy, I think you need to consult with an experienced ERISA disability attorney, because depending on where you live, will impact what the court does. Now, there are some states that do not allow for these arbitrary and capricious or discretionary review clauses in a policy. And that means that the judge gets to substitute their own view. It's called de novo review. If you're in a circuit like the First Circuit that has a habit of just rubber stamping denials based on the arbitrary and capricious standard of review, that can be a problem. And you need to know, how is the court going to review this case if I end up in court? Because that, I think, will impact what it is you need to prove. You obviously need medical proof. And in this particular case, he should have had an EMG and nerve conduction study test to document the objective basis of the diabetic neuropathy. So the next point I want to make is that obviously it's an issue of medical proof. If your claim has been denied, obviously you'll only have 180 days in which to file an appeal. And some of these defects can be cured in an appeal. So call me at 727-894-3188 for a complimentary review. We can look at the policy, we can look at the denial, we can look at your medical records and try to figure out if we can fix this, and if so, how. You owe it to your family to get legal advice that will help you make a wise decision about applying or appealing a decision. Call today at 727-894-3188. I can help you regardless of where you live in the United States.